Clarence Affirmative Action Thomas benefited from the very program that he decided to gut recently. Yes, United States Supreme Court Justice Clarence Thomas literally benefited from affirmative action. Let's get into it. I have the background, the details, and the insanity. Affirmative action policies at college campuses across the United States were effectively banned after a United States Supreme Court ruling that put an end to years of precedent. The policy, which had aimed to help increase minority college admissions, was prohibited after SCOTUS was asked to consider whether colleges should no longer be able to use race as a consideration when admitting students. They are standing behind Article 14. Article 14 of the US Constitution provides protection for equality, equal protection clause. Let's dive deep into what has really happened. I'm a college professor. The reason why universities will take race into consideration is the enrichment of the overall experience. Colleges have the ability to place parameters on recruitment and admissions. Many people are under the false impression that affirmative action, which by the way, is not really a policy, it's a set of policies to enhance diversity. But many people are under the impression that affirmative action means that you take a qualified person and you remove them from entry to accept a non-qualified person. That is not how affirmative action or diversity inclusion programs operate in higher education. The way they work is this, very simple. You must meet the requirements to even be considered. You must meet the standards placed by the institution. Once you meet those standards, after that phase has been accomplished, the institution is able to then consider other factors, such as leadership capacity, the ability to overcome difficult circumstances, your participation in extracurricular activities, and yes, even race. Not because of skin color alone, but because of the adverse experiences the skin color, the immutable factor, will bring to you. And because of the historical injustices done by individuals who were less than good faith actors when it comes to accepting students into colleges. But at the height of hypocrisy, Clarence Thomas, US Supreme Court Justice, not only benefited from being an affirmative action student at Yale Law, he also talked about discrimination, racism inside of the Catholic Church when he wanted to become a priest. And then he moves on to go to Yale Law under their affirmative action clause. Beyond that, he gets appointed to the Civil Rights Division of the United States Department of Education. After that, he becomes chairman of the Equal Opportunity Employment Agency. Let me give you the background. Let's put it up. Representative Richey Torres, a New York Democrat, on June 29th, 2023, he posted, and I quote, "Imagine dismantling a program that gave you the opportunity to be a student at Yale Law and then a justice on the US Supreme Court. The mind of Clarence Thomas, the American dream for me, but not for thee," end quote. Let's put up Pastor Bishop Tolbert Swan. He said in a post that has been viewed over 1 million times, he was admitted to Harvard Law School in 1971, right after it adopted a race-conscious admissions policy, but chose to go to Yale at the exact moment it created its first explicit affirmative action program with the goal of 10% minority enrollment. Now, there are those who will push back and say, well, Doc, we have no evidence that Clarence Thomas came under that provision of Yale. We have no evidence that he was there by way of affirmative action. Well, let me provide the context to the narrative. While Clarence Thomas did not deliver the Supreme Court ruling, he did write a 58-page concurring opinion saying the foundational policies of affirmative action, quote, fly in the face of our colorblind Constitution and our nation's equality ideal. In short, they are plainly and boldly unconstitutional. Well, isn't that interesting? Clarence Thomas calling the US Constitution colorblind. Can I say something about that statement? You see, the US Constitution was never written for the people. The US Constitution was never written by the people. The US Constitution was written for rich white males, and it was written by rich white males. Women could not govern. Women could not run for office. Women did not have equal rights nor equal protection. Black people obviously could not run for office, could not govern, and it did not provide equal protection. You see, the Constitution is actually a flawed document. Most are unwilling to say that out loud. That's the reason we have an amendment process. It is meant to correct the necessary corrections that are needed inside of the Constitution. Amendments are fancy words, it simply means a correction. So here's what we're gonna do. We're gonna give you the facts. 1991. In 1991, New York Times article about Clarence Thomas reported how Yale University officials said Clarence Thomas was admitted to his law school, and I quote, under an explicit affirmative action plan with the goal of having blacks and other minority members make up about 10% of the entering class. Professor Abraham S. Goldstein, dean of the law school from 1970 to 1975, was quoted by the Times as saying, we did adopt an affirmative action program, and it was pretty clearly stated. There's more. A 1994 Yale Alumni Magazine article underlines this, stating, quote, like most American universities, Yale in the 1960s and 70s embarked on an aggressive policy of affirmative action in admitting and hiring minorities and women. During a 1980 Washington Post interview, Clarence Thomas said, quote, you had to prove yourself every day because the presumption was that you were dumb and didn't deserve to be there on merit. Every time you walked into a law class at Yale, it was like having a monkey jump down on your back from the Gothic arches. The professors and the students resented the very presence, end quote. Clarence Thomas has literally gutted the program that saved him. Now, I will say this. It does impact many colleges, but not most. Most colleges have found other ways to instill diversity. It has definitely had an impact on institutions like Harvard and Yale and others, where competitive entry is paramount. But even though that's bad, what's coming is worse. This ruling is not the end all. Colleges actually have a way to still work around the ruling. Let me explain. Universities can in fact utilize a person's experience with race, experience with discrimination because of their skin color as a prerequisite or a qualifier considered during the admissions process. So what does that mean? Institutions who want to do it right will have the ability to do it right. Institutions who do not will no longer be mandated to do so. That's how that works. Thomas was made Assistant Secretary for Civil Rights in the United States Department of Education in 1981. President Ronald Reagan appointed Thomas as chairman of the Equal Employment Opportunity Commission the next year. President George H.W. Bush nominated Thomas to the United States Court of Appeals for the District of Columbia Circuit in 1990. He served in that role for 19 months before filling Marshall's seat on the United States Supreme Court. Cause and effect. Look at the lineage here. Clarence Thomas gets accepted into Harvard under a diversity inclusion program. He doesn't go to Harvard. Instead, he goes to Yale under their aggressive affirmative action program. Without Yale, Clarence Thomas never becomes the civil rights director inside of the US Department of Education. Without that role, he never becomes chairman of the Equal Opportunity Employment Commission. Without that role, he never becomes a member of the federal bench through the US Court of Appeals. And that role is what quickly qualified him to become the first black male conservative to sit on that bench. Now, let me say this. There are those who are saying this was a good thing to do. I respectfully disagree. Not because the implementation of affirmative action was appropriate, definitely had mishandling in the implementation. White women actually benefited most from affirmative action policies when you actually aggregate the number. This is a bad ruling because of what it does next. It now creates the legal framework to argue that all diversity and inclusion programs, public and private, are no longer legal. That is what this ruling does. Florida, under the leadership of Governor Ron DeSantis, Florida has given you the blueprint of what they want to do. Don't ask yourself anymore, what did they mean by Make America Great Again? You're seeing what they meant right here. We will have more about this during the bullpen. I'm saving some of it for my debate guest. But this is not only a bad ruling for the nation, it's a bad ruling for the generations that will come. I am sick and damn tired of Democrats being so reactionary when they saw the writing on the wall. There are things that can be done and they should be done immediately.